Ed, the scroll of your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all caps.
The video opens with the defendant immediately launching into classic sovereign citizen jargon, insisting he is the agent authorized to represent, a name written in capital letters. The judge humors him, but it's clear she recognizes the tired script designed to challenge jurisdiction. This is the moment where the viewer sees the sovereign citizen mentality collide with courtroom reality, and the contrast is almost comedic. The judge remains patient, but her tone shows she's already preparing for the frustrating road ahead. What makes this even funnier is how confidently the defendant delivers these lines, as if reciting magic spells that will somehow override the law. It sets the stage for a hearing that will test the court's patience more than its legal knowledge, and you can sense the tension rising even before the real issues begin.
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, that language doesn't make any sense. So
No, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's in all caps.
I'm not a person. I am one of the...
As the prosecutor describes her attempt to read the defendant his charges, we see the usual sovereign citizen refusal tactics emerge. He interrupts, resists basic communication, and hides behind the phrase sovereign capacity, which he seems to believe grants him immunity. The prosecutor, however, calmly continues, making it obvious she has dealt with this behavior many times before. This exchange highlights how the legal system remains functional even when a defendant insists on playing pretend. The contrast between a trained professional and a deeply misinformed defendant is stark, almost theatrical. This moment also reminds the viewer that sovereign citizen arguments may feel dramatic to those who use them, but in a courtroom, they crumble instantly.
Hey, hold on. We're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony, probable cause application will be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was.
When the judge tries to clarify that agent or person makes no legal difference, the defendant proudly announces he is one of the people, which only reinforces the judge's point. His attempt to escape the label person is both humorous and revealing, showing how deeply he misunderstands the legal definitions he tries to weaponize. The judge maintains calm authority, refusing to let language games derail the proceedings. This part captures the fundamental flaw in sovereign logic. They attempt to redefine legal terms but forget that courts operate on established law, not personal interpretations. The commentary from the narrator reinforces the absurdity, comparing the defendant's argument to a toddler arguing semantics. It's a perfect example of how sovereign citizens confuse themselves more than the court.
To manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault
Honor.
case?
Based on the new law violation, yes.
Thank you. And let's see.
The officer's report paints a clear picture: intoxication, belligerence, threats toward store employees, and refusal to leave. A straightforward trespassing case. But the defendant's bizarre defense instantly undermines him when he claims he was too drunk to be held accountable. This moment becomes a comedic highlight because it reveals a rare and extremely misguided legal strategy, admitting guilt while arguing that intoxication erases responsibility. The court and viewers immediately recognize how nonsensical this is, yet the defendant clings to the idea as if it's legally profound. Instead of building a defense, he builds a confession sprinkled with misplaced confidence. This part exposes how sovereign citizens often try to combine pseudo-legal logic with excuses that make the situation worse.
Deferral, it was a stipulated order of continuance.
That's correct, Your Honor.
All right, thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will. And Mr. Milton is asking not to be represented by counsel, is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
The officer gives the defendant ample chances to avoid arrest, even allowing him to manually push his car to avoid driving drunk. Yet, despite such leniency, the defendant returns to the store and repeats the exact behavior that got him trespassed. His excuse remains unchanged. He's too drunk to be held accountable, which transforms the incident from a mistake into a pattern of self-inflicted legal harm. This section shows how some sovereign citizens mistake patience for weakness and continue escalating. The commentary highlights the irony of leaving his phone behind twice, adding a layer of ridiculousness. The defendant isn't just breaking the law, he's doing it clumsily, repeatedly, and with the confidence of someone who thinks the law won't apply if he insists hard enough.
The court cannot assist you in recognition of the fact that you're not an attorney, so you will end up missing things you're supposed to do, you will do things you're not supposed to do, and all of those things will likely work to your detriment So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay,
Your Honor.
even know the right term, okay? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights.
When discussion turns to his past assault case and the city's motion to revoke his continuance, the defendant begins to realize the seriousness of the consequences. Yet, instead of confronting reality, he retreats back into sovereign citizen posturing, insisting he wants to represent himself. The judge offers a thorough explanation of the risks, clearly outlining how self-representation almost always harms the defendant. Her tone is patient but firm, like a teacher explaining basic rules to a stubborn child. What makes this part stand out is how the defendant confidently chooses the worst possible option, convinced that his YouTube-level legal knowledge will rival trained attorneys. The viewer is left watching a predictable self-destruction unfold in slow motion.
Internet access so that I can properly represent myself. If you would
Okay,
write that into a court
Read
order.
your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything,
Okay, is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't
Oh,
been
reading.
Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this.
When asked whether he attended law school, the defendant dodges with a dramatic, "I can neither confirm nor deny," as if answering a spy interrogation. The judge remains unfazed, calmly pressing until he admits he has no legal education. The narrator's comedic interjection emphasizes how sovereign citizens often rely on theatrics instead of substance. This scene exposes the gap between confidence and competence. The defendant believes clever phrases can replace expertise, while the court deals only in procedure and law. It becomes another moment where the judge's professionalism carries the hearing forward, despite the defendant's attempts to derail it with irrelevant grandstanding. His bravado becomes both entertaining and self-damaging.
Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was
Okay, yeah, hold
In
on.
possession of a cell. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay, anything else?
That's it for now.
Okay.
The defendant complains he has not been read his Miranda rights, misunderstanding that Miranda applies to custodial interrogation, not arrest itself. The judge reminds him that he must navigate all legal procedures alone since he chose self-representation, indirectly showing how lost he already is. Meanwhile, the narrator jokingly imagines lawyers everywhere smashing their keyboards at his confusion. This part highlights the most common sovereign citizen mistake, believing that procedural misunderstandings can magically erase charges. Instead, his comments only confirm he lacks the foundational knowledge needed to defend himself. It becomes painfully obvious that the defendant is building a legal disaster, brick by brick, while the court simply documents each misstep.
Questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right. Which is one of the reasons. Don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right.
When given the chance to argue for release, the defendant provides the least persuasive statement possible. Instead of addressing the issue of bail, he wanders into unrelated accusations, stolen property claims, and irrelevant grievances. His inability to stay on topic perfectly demonstrates why self-representation backfires. The judge only needs a few seconds to conclude that he failed to present any coherent argument, essentially sealing his own fate. This moment captures how sovereign citizens often sabotage themselves, not because the court attacks them, but because they cannot engage with the legal standards required. It becomes a masterclass in how not to argue for your freedom.
Badger County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me semi-realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is $300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be.
Even after losing his chance to argue, the defendant tries to continue, repeating the Miranda misunderstanding and insisting he wasn't properly informed. The judge patiently explains the actual purpose of Miranda, making it clear that none of his objections prevent the case from proceeding. This final part encapsulates the entire hearing. A defendant convinced he understands the law battling a court that actually does. His misplaced confidence meets unwavering judicial clarity, and the result is a predictable legal defeat. The narrator's tone makes the scene even more entertaining, emphasizing how the defendant's downfall is entirely self-engineered. The hearing ends with the same energy it began, the system functioning while the sovereign citizen insists on fantasy.